We have got a case at the U.S. Supreme Court right now. This case is about New York Times versus Sullivan, which is defamation of public figures. And the definition of public figures has certainly changed with social media. Basically, everybody can be a reporter. Everybody's putting videos up. So the definition of it versus the time when that case came out, very different. But the idea is that if you are considered a public figure, the news doesn't just have to make a misstatement or lie or get the facts wrong about you to file a lawsuit for defamation. You have to actually prove, as the person who was injured, that you have to prove that it was actual malice by the media organization, which is a very high standard. So it's like they knew it was wrong and they were doing it because they wanted to hurt you. So that standard, of course, you have to get into the minds of people, and the burden is on the person who they lied about. The burden is not on the CNN to show that it wasn't actual malice. Somehow you, the public figure, have to show that there was actual malice, which means getting inside a newsroom, getting inside the heads and intent. And so as the world has changed and as the media has changed so rapidly with podcasts and all these issues, I mean, almost everybody could fall under the line of so many new people, not everybody, but so many people could fall under this public figure. Yeah. And then if someone says horrendous things about you, you have no legal recourse if you can't prove actual malice. So this case challenges that standard. And this is what happened. When we filed, CNN waived their right to reply to our application. So for the court, the cert petition for the court to take the case. That was because they were hoping the court would just take ours and then say, okay, we're not, they take it to conference just with ours, and that means likely not hear the case.
Right, throw it out.
The Supreme Court yesterday gave CNN a deadline to reply. So even though they waived their reply, they are now being asked by the Supreme Court to reply to our brief, which means it's not 100% the Supreme Court will take the case, but this is exactly what CNN did not want to happen. So their strategy was, we're not even going to respond. We'll let the court just handle this, and the court has now handled it by saying, we want your response within a month.
Yeah, this is a good moment.
Well, exactly. And when you looked at the decisions by the lower courts that got it up to this level, many of them ruled in favor with CNN because of the New York Times v. Sullivan reasoning, even with judges at the appeals court level saying, under all standards, this is defamation. However, because of New York Times v. Sullivan, we cannot find that there was defamation here. So even that, the lower courts push it up to that Supreme Court question of, is the New York Times v. Sullivan standard even still relevant in its form as it is? And that's exactly why we're going to the Supreme Court with it.
The importance of this is then we will have the opportunity to respond again to CNN for the lies that they told about Professor Dershowitz. Just let me tell our ACLJ members and our ACLJ champions and those listening to the broadcast, remember what this case is about. Alan Dershowitz, who's a Democrat, was one of our defense attorneys at the impeachment trial, the first one of Donald Trump. He was one of my co-counsels. We brought him into the case. He handled specific constitutional issues, very specific, saying that there was no grounds to impeach the sitting president of the United States during that proceeding. He got a lot of flack from the left on that, as you can imagine. But what happened was CNN went on air as soon as he was done with his first presentation, misstated his main thesis of the case. In fact, they said he said the opposite. So under the New York Times versus Sullivan, when you're dealing with a public figure, they basically had, as you said, Logan, blanket immunity. They could say whatever they want. You had the standard that we would have to reach to prove defamation is very, very high. But what's interesting here is one of the judges at the 11th Circuit Court of Appeals said that the only thing standing in the way from Professor Dershowitz and justice is this old 1964 Supreme Court case, which actually talked about public officials, like government officials. It didn't even really talk about public figures. You want to know an interesting side note here, Logan and Will, and that is Alan Dershowitz was a law clerk for Justice Goldberg in writing a concurring opinion on that very case. And it was taken way further than what that initial Supreme Court decision meant. So this is a chance to right a wrong and to reflect the media as it now is.
Once again, this is obviously a completely different media landscape than it was when that original Supreme Court opinion was issued, and as even it shows that the person bringing this, Professor Dershowitz, was one of the people that helped craft the concurring opinion in that issue. But I think also we can't normally forecast or tell what the Supreme Court's going to do. It's very mysterious to the outside, the way that they hold their conferences, which cases they decide to take and which they decide not to. But it does seem that this is at least a good sign that there are justices interested in reviewing New York Times v. Sullivan, that when we filed our cert petition and CNN decided we're not even going to bother replying, that now the Supreme Court wants to hear what CNN has to say to defend itself.
Yeah, it's interesting because generally when the strategy of not responding, which is what they initially did, was also to kind of get a temperature read of, is the court interested in this or not? For instance, we were set for a conference to vote on certiorari on Thursday. They were to vote tomorrow on the case, whether they were going to hear it or not. But what happened here was CNN was hoping that there would be no order. It would go to conference and be denied. But instead, a number of justices of the Supreme Court said, no, we want to hear what CNN has to say, and then we'll decide if we take it. So it's going to delay it until probably April, maybe even May. We'll file another round of briefs in this. But this is a really significant case for accountability in the media and long overdue.
When you go back to 1964, when this case came out, Dad, and you look now to 2026, who is a public figure has changed so much. I mean, it's not just a handful of people who make it on 3 TV channels or are well known in local news or newspapers, and it's there's so many citizen journalists and podcasts and people in the media and the Netflix, all these different ways. It's not the same kind of control, so that it makes it nearly impossible for anyone who's got any kind of name out there and following to bring a defamation case where someone has absolutely either lied about you or just recklessly disregarded. That means you don't care if it's a lie or not, to show that actual malice standard. But you, the plaintiff, it's also a bizarre move in court, have to prove the intent of the defendant in this case. I mean, you have to show what was going on in their head or in their newsroom as they were putting the piece together. They don't have to defend it. You have to actually present it, which also makes it almost an impossible bar to overcome. So, and this is, I think, in the changing media landscape, the perfect time for the Supreme Court to look at this, to say, you know, this might not be the right standard anymore for 2026 and onward.
Well, I think, Jordan, that's exactly right. You had a dual burden here, which you don't have in any other kind of case. So that you had this dual burden where you had to meet the threshold of knowledge of falsity, and then the burden was on us to establish the issues rather than the defendant having to establish their defense. But look, the fact that the Supreme Court said we want to hear from you on this is a very positive development. Alan Dershowitz was wronged. We want to make it right. That's why we're stepping in and hold the media accountable. We get so many calls where people say we want to hold the media accountable. This is that case.
And Dan, we have 2 now cases pending at the U.S. Supreme Court, one out of Calvary Chapel in California, and those unbelievable fines that California, millions of dollars of fines, they want to still levy, the state of California, against the church, the Calvary Chapel church there. And, of course, this case, and we're both before the U.S. Supreme Court, the ACLJ handling those. I just want to remind people, I mean, these are happening nearly simultaneously, Dad.
I want to encourage our ACLJ friends and members, and especially our ACLJ champions, support the work of the ACLJ. You've got 2 great examples here. The church case, the case against CNN, it happens because of your support to the ACLJ. Go to aclj.org and join our team. Very important that you stand with us.
That's right. We have a petition right now, and we can hold the mainstream media accountable at aclj.org/sign. Because look, as Jordan said, so many of us have gone from what you'd consider, radio personalities to television personalities to now anyone really can kind of fit in that world of being a public figure, as we are all on social media. So this protects you as well. Of course, this is doing it from the mainstream point of view, but there are many different ways that this could upend current settled law that has been a pain for all of us. for many, many years, including, like I said, there are so many people who had rightful claims to this, who have reached out to us over the years, and we've had to have that very kind of sad and serious conversation with them saying, sadly, there is nothing we can do. You're a public figure. The actual standard to get any kind of libel defamation was so high that essentially we knew you could just go out there and lie. But you have a different court, it's a different day.
Well, it's when you look at a lot of the stories that are going on in the world right now, even with Don Lemon, with the protections that he's trying to claim, the heightened protections because of being a journalist. It is something that for a long time, the media has gotten an extra level of protection than what the First Amendment just affords to everyone else. So I think it's important that something like New York Times v. Sullivan be re-examined by the court. And that's exactly what we're doing here.
That's right. You can be a part of it today. You can join with us. Go to ACLJ.org. Again, take action. Add your name to that petition at ACLJ.org.